I'd like to introduce Mona Nia, who is the newest member of the Estate Planning and Probate Section Board. And she's going to introduce Judge Reiser today. So Mona, I'm going to turn it over to you.
Thank you, Anne. On behalf of the Estate Planning and Probate Board, I would like to welcome everyone and thank you all for attending today. I know all of you are looking forward to Judge Reiser's presentation, so I'm going to try my best to keep his introduction short. Judge Glen Reiser currently works with JAMS as a mediator. He primarily focuses on resolving trust and conservatorship litigation matters. Before becoming a judge, he worked more than 2 decades as a litigation attorney, focusing on prominent trust and estate matters. He served as a trial judge for the Superior Court of Ventura County for more than 20 years. For the majority of his tenure, he served as the supervising probate judge, handling trust, probate, and conservatorship matters. As a mediator with JAMS, Judge Reiser managed the litigation resolution affirmed in Breslin v. Breslin. Judge Reiser continues to serve as a judicial trainer for all judges in California that are assigned to the probate bench, with an emphasis in trust and conservatorships. So without further ado, I am happy to present Judge Reiser.
Well, thank you, Mona. It is a pleasure to be here on this Friday afternoon. Hope everyone has plans that don't exclusively include work this weekend. As counsel stated, I am Judge Glen Reiser. I'm going to talk to you today about the Breslin case, and I'm going to try periodically to, if there are questions that come up, and certainly questions at the end, right? Because Breslin is just it's a initial foray into a new area of procedural jurisprudence, and so questions, if you have them, specific or general, feel free to ask them, and I promise I will get to all of them at some point, either during or following the discussion. So Breslin, which is a case that came out last year, wouldn't exist except for a prior decision that came out of that derived from the same appellate court. Okay, and that's a case called Smith versus Szyller, because we never, I didn't think of Breslin until we read Smith versus Szyller. And when Smith versus Szyller came out, it's a very odd case with a very odd set of holdings and, arguably dicta. But it got me thinking that maybe there was a different way to resolve cases. And so we're going to talk a lot about Smith, because Smith you can use as practitioners in a lot of different contexts, not simply in as the precursor to Breslin, but there are a lot of things in Smith that are a bit counterintuitive, but are all ammunition that you can use in your other cases in a lot of different dimensions. And then we're going to talk about Breslin itself, and not just the holding in that case, which most of you know, but some of the permutations and consequences of that, and the unanswered questions associated with Breslin. So without further ado, let me start the deep dive. So in Smith versus Szyller, right? So Don Senior and Gladys moved later in life to northern Santa Barbara County, the wine country, San Ynez Valley. The courthouse is in Santa Maria. And Don and Gladys had 5 children: Dave, Donna, Dee, Don Jr., and Joanne. And I put a star by Joanne's name because she is highlighted in that case fairly prominently. And we're going to talk a little bit more about Joanne as we move forward. So to my estate planners in the group, and I'm sure I have a number, it was a standard, this was an ABC trust, right? So, and there was nothing odd about it. There was the B trust, right? The bypass. There was for the amounts over Don Senior's exemption sum. There was a Q-tip, which, there was some principal invasion authorized, consistent, with the federal law. And then there was the A trust, right, which, as is normally the case, the survivor can amend through the survivor's lifetime. All trust income, in this case, went to the surviving spouse, which turned out to be Gladys. And she had limited rights, to principal, both in the bypass and the C trust, the Q-tip, right? So, but everyone was an equal beneficiary. This was a really good estate plan. There's nothing wrong with this estate plan. Lovely estate plan. But then, of course, Don Senior passed, and he had a fairly, meaningful estate. And so, Mom was by herself, and Joanne said, I'm going to move back to California. And my husband, Edward, and I, we'll retire from our jobs, such as they are, and we'll go move in with Mom in northern Santa Barbara County. And so, lo and behold, as we know in many of our cases, and certainly as a neutral who does almost exclusively trust probates and conservatorships, stuff happened, and Mom, through influence or otherwise, decided that Joanne was going to get a bigger share of the survivor's trust estate. So Donna, who was conserved at that point, right? So there may have been other reasons to deal with the estate plan associated with the conservatorship, because who knows, about that asset situation and who was subsidizing Donna. But D-share, sister D-share, was just simply turned over to Joanne, and Donna was cut out completely. Okay. And then Joanne and Edward were, before Mom passed, were managing assets in a Geraldine sort of way, where they had a lot of control over what Mom did. And then Mom passed. And I want to have just a brief disclaimer here. I do this when I talk about Szyller. I use photographs, icons to interpret case law, right? And so the lower right-hand corner, while I intended that to portray Joanne, that is not really Joanne. And when Smith versus Szyller came out, I actually went to Santa Barbara County and talked to the local state planning council up there and talked about the case. And the lawyers for Joanne said that it was not a fair depiction of their client. And so I just wanted to give you that disclaimer. This is my First Amendment right of fair comment. So that isn't actually Joanne. That's just my view of Joanne. So then Joanne and Edward, her husband, oh yeah, and Edward wrote me a nasty letter too, but anyway. So Joanne and Edward, the successor co-trustees, allegedly spent more than $2 million of their parents' trust funds, Joanne's parents' trust funds, on personal items. There's a Shumash casino there up in San Ynez, or down in San Ynez, depending on where you are. And there was a lot of gifting going on. And so at some point after Mom passed, Don Jr., who was, one of the 5 children and Joanne's brother, he filed a very perfunctory petition for information saying, I want to know what's going on. And I really would love to see an accounting, Joanne and Edward, of what's happening, not only with, the survivors trust, but certainly in the trust that had previously become irrevocable when Dad passed. So Joanne, gets served with this, and so she does a verified accounting through her counsel, but there was a very large plug number, and that was a problem because that created further unanswered questions. So Don followed up with a verified petition saying, we ought to remove Joanne and her husband, Edward, for breach of trust, because there's a plug number and it's 7 figures. So Don's petition for removal and surcharge also included a prayer for his attorney fees, and that's important in this case, from all the subtrusts, because he said that removal would benefit the beneficiary. So as we all know, the law of attorney fees in trust and probate is, it's like a Gatling gun, right? You have to find specific code sections, and generally to recover attorney fees, you have to show bad faith by the other party, and so under the removal statutes, you can recover attorney fees if you can show bad faith. Most of the statutes, the attorney fee statutes, require bad faith. 859 requires bad faith. The one involving creditors' claims is a little different. It requires unreasonable conduct. So getting back to this case, right? So there's three siblings, right? Donna's conserved, so Donna is a conservator, but brother Dave and sister Dee, they're watching Don Jr. and Joanne go at it, and they don't want to spend the resources to watch this battle royal. So as we had seen, throughout my career, there were a number of beneficiaries who were watching, and so I'm depicting them there on the sidelines. Joanne and Edward, in the midst of this litigation, they really did not want Dave, Donna's conservator, or Dee to participate. So they did the next best thing. They said, we'll have a preliminary distribution of the trust that should have distributed way back when, and everybody's going to get $200,000. And that apparently did sate Dave, Donna's conservator, and Dee. So they didn't jump into the fight. They collected their 200 and they continued to observe the litigation battle. So then Don Jr., who gets the amended accounting, thought, well, now's the time to do I'll call it a companion civil action for violation of the Welfare Institutions Code. A lot of attorneys do it as part of the probate and trust petition. A lot of lawyers do a separate civil. The way I teach my colleagues is, if you're aware of a separate civil elder abuse action, which utilizes some or all of the same facts, the best solution is to consolidate and then bifurcate, do the equitable issues first, meaning do the trust case first, push the jury trial side of it to the latter portion. The equitable case, the fact finding by the court, will usually resolve the other case. And so the idea being, you'll never want to try to impanel 13, 14, or 15 jurors to sit there for 2 or 3 weeks to hear about how terrible our clients are. So that's what's going on. And so Northern Santa Barbara County, they do things a little differently. It's not the downtown Santa Barbara court. They like to litigate up there and didn't mediate or resolve the case. And so after the third day of trial, oh, by the way, Dee and Dave were actually at the trial as witnesses. And on day 3, the judge says, you guys go home because the lawyers are going to try to settle this case. And the judge suggested strongly to the lawyers that the case ought to resolve because Don Jr. was presenting his case, and the judge felt that Joanne ought to be reading the writing on the wall. So, oops, I'm sorry. So I'm going to jump back into that page for a sec. So, So a settlement is reached between Don Jr. and Joanne, but interestingly, Don Jr. did not want anyone else to know how much he was getting from his sister. And when I say anyone else, I'm referring to as the 3 non-participating siblings, because Joanne had a bunch of money, right? There was a $14 million trust. Yes, there was a B and a C subtrust, but the survivors trust, was more than $7 million at its, at the time of the, at least in carry cost, right, and carry value. So there was a lot there, and she's And she was also resourced under under the bypass and the Q-tip. So she had a lot of money to pass over to Don Jr. to resolve that case. And she did. It was confidential. I don't know what the settlement sum was. I'm pretty positive the Court of Appeal didn't know what the settlement sum was, but Don knew what it was. And Dee and Dave and Donna's conservator had no idea what this confidential sum was. But it certainly benefited Don Jr. and nobody else. You need to remember. So also under the settlement that was reached in the trial court, outside the presence of the judge, but in the courtroom when the lawyers were negotiating, the agreement was to appoint a referee to prepare 706, right? And the final account. And this was why I depicted a nuclear explosion. The subtrust, even though they were really fighting over, to a large degree, over the accounting on the survivors trust, Don Jr. was going to get almost $750,000 in fees and costs from all of the subtrusts, including the Q-tip and the bypass, which really affected Dee and Donna's conservator, because their shares got deleted in the survivors trust, right? So they were shocked because there's all this litigation and they're not getting the benefit. Don Jr. is getting the cash, but they're getting hammered for $750,000 in fees and costs collectively, right? Of which the other three beneficiaries have 60% of those subtrusts. So also under the settlement agreement, all the future attorney fees incurred by the litigating parties had to be paid by all of the subtrusts. Again, 60%, plus percent of those are Dee and Donna and Dave obligations. And then and this is one of the odd thing, right? So in trust, probates, and conservatorships, right? We're not radicals. We don't do crazy things, but rather than proceed by a petition to approve, which I think is just understood by practitioners in our world, 17-200 petition for instructions, subcategory petition to approve settlement with statutory 17-203 notice. That's not what happened. They just handed it to the judge and the judge signed an order after trial. No notice, and it included all the settlement terms and the findings. So the trial court, as part of those findings that were drafted for the trial judge's signature, it said the litigation benefited all 5 beneficiaries, and this was the language, by acting as a catalyst to the improved preparation of the accountings. Okay. Did it give millions of dollars to Don Jr.? Yes. Is that what they're talking about here? No. So, it's cattle country up there in Santa Maria. And so if we want to wear the big boots when we read this, we can, because we're walking through a bunch of fields. And so after this goes down, Donna's conservator, who's her son, makes an appearance and moves for a new trial and to vacate the judgment. And her son, on her behalf, argued there's nowhere in the pleadings this attorney fee award is supported, right? There's no attorney fee declaration in the file. That number just is out of the blue in a 2, 3, 5-page settlement agreement, however long it was, that Don Jr., this attorney fee award is disproportionate to any of the benefit the other beneficiaries got, because he's the one getting all the dough, confidentially, of course. They don't get a cent of it. All they do is get the burden. And then the last argument was there's a due process problem here, because we didn't know about any of this until after the fact, and you didn't even give us notice. Check question here. Question, what is a plug number? Okay, so in the accounting world, as I understand it, right, because I've got a legal background, if there is no explanation for something and there's a gap, they just put in a number saying, I don't know what that is, right? And so that is, as I understand it, that's what they use for plug number. We're putting a number in there. So the balance, the beginning of the accounting where everything has to balance, they have to sort of equalize things. And so if they don't equalize, there's a problem. And if you don't know what the problem is, you kind of put in the number that's the difference and go, yeah, I don't know what that's all about, but that's the number that equalizes everything in terms of, disbursements and receipts and so on. So the trial judge, in Santa Maria says, well, we don't do new trial motions in probate. So I'm not going to think about that. And probably more importantly, the trial judge says, Donna, who was the one complaining at that point, forfeited her objections because she didn't earlier object to anything going on in the case. Interesting. Okay. And so it goes to the Court of Appeal, right? And by the way, while the case is being litigated out, Donna passes and her son, who's her conservator, becomes the administrator of her estate because she can't do it. She's conserved and they don't do a 2580, so she doesn't have a will or trust. So it's an intestate estate and the son becomes the administrator. So so the argument is, how can private settlement terms be findings, right? There's judges making findings based on a piece of paper that two litigants give. And the Court of Appeal says, Donna chose not to participate in the trial and cannot now second guess the resolution. The litigating parties resolved disputed facts, and the court was bound by that resolution. Okay. Also on the due process argument, Donna's administrator at that point did what all of us would do. We say, where's the 17,200, right? That's how we get notice. And then the Court of Appeal looks at that and says, well, due process doesn't require the parties to use other procedures such as a motion to enforce a settlement, 664.6, which wasn't applicable there, or a petition for approval of a settlement or a new accounting. Such procedures were necessary because the dispute was before the court on properly noticed petitions and objections. So the court is saying the initiating petitions were all the notice you need. And kind of, if you're not there, it's too bad, right? Then there was the argument, which I thought was a pretty meaningful one, that the trial court was acting in excess of jurisdiction because this request to allocate attorney fees on substantial benefit was never pleaded. And certainly there was no motion to reallocate attorney fees to the other beneficiaries. And the Court of Appeal, and I think that's the reason that Smith versus Szyller was published, as odd as the case is. They're saying this is the first case that in the trust world that applies the substantial benefit doctrine, because historically we use common fund to force the non-participants to share in the prevailing party's attorney fees. They go, yeah, well, substantial benefit also applies in addition to common fund, because remember, Don Jr. didn't create a common fund. All of the settlement money went to him, and all the attorney fees reimbursement went to him. So on that, with the argument that it was never pleaded, and this is a bit of a stretch. I mean, this is as odd as anything in that case. Court of Appeal goes, well, it was pleaded because there was a removal petition that asked for attorney fees. Okay. But Joanne never got removed. She's still, after the settlement was and Edward were the trustees. And so the Court of Appeal said that the theory that Joanne was never removed was countered by the trial court's explanation. There's no reason to appoint new trustees for the purposes of emotional victory. Those of us who work in this world, emotional victory is most of our cases to a large degree. But that being said, it was used here as a rationale for applying a removal statute to justify attorney fees, even though nobody got removed. So you can see, as I'm moving through this case, right, it's getting a little more peculiar. What about the substantial benefit? Because Dave, Donna, and Dee, you know, all the substantial benefit went to their brother, and all they got was detriment. And this is what the appellate court says. And I want you to look at this language, because as suspect as it might be in this case, you can use it in your other cases now to argue substantial benefit, right? They say, and this is the language, this litigation maintained the health of the subtrusts. Well, that's an amorphous concept, isn't it? Raise the standard of fiduciary relations, perhaps even more amorphous, right? Accountings and tax filings, and prevented abuse. Prevented abuse meaning they stopped being bad. It is not significant that the benefits found were achieved by settlement of plaintiff's action rather than by final judgment. So this sentence was what the catalyst for me thinking, well, why do you have to settle if this case is legit, which it is because it's the law of California now? Why do you have to settle in the courthouse when the judge is not there? Why can't you settle outside the courthouse when the judge is not there? Because if the logic of this case holds true, then maybe we can do settlements that are binding by parties who are ordered to be there, right? There was another argument that, hey, there's no attorney fee declarations in the file, and so how do you get to the 721? And the Court of Appeals says, well, there's no need for billing records in that case, because the only parties who contested the award agreed to it, right? And they say, had Donna responded to, and this is a practitioner note for all of you, had Donna responded to or objected to Don Jr.'s petitions, she would have been entitled to an evidentiary hearing on the question of the reasonable value of services rendered, but she did not. Meaning the brother is trying to get money back for everybody by petitioning for surcharge, and the court is saying, well, you should have gone in and objected to those petitions when they weren't objecting to them. They were, you know, they were favoring those petitions. So next argument was, oh yeah, so if you're going to use substantial benefit, why don't you apportion it between those issues where all the benefit came, meaning if Don Jr. is going to get this giant settlement, why doesn't he pay the lion's share of the substantial benefit? And this is another concept that you can use in your other cases that aren't specifically on these points. The Court of Appeal says Donna contends the court should apportion the fee award because most of the fees were incurred by Don Jr. prosecuting his elder abuse petition, right, to get damages, and not for the benefit of the subtrust, which was the previously stated rationale for the substantial benefit. And the Court of Appeal, bless their heart, says apportionment, however, was not necessary because the pleadings were completely intertwined and relied on the same factual allegations. So completely intertwined is now the rule, I guess. When somebody says, well, let's apportion, you go, oh, everything's completely intertwined, Judge. Read Smith versus Szyller. So very odd case. And very, you know, it's not an intuitive result in Smith versus Szyller, right? It seems to be contrary to how we've done things, historically. So, but as I was, you know, as a judge and an academic, right, and I was neutral, as I was teaching Smith versus Szyller, I thought, well, okay, so what's the difference between telling somebody at trial, I'm going to go in the chambers and you guys work it out, or late, or women, or whatever, right? Parties, because sometimes in charities, they're not people, they're entities, right? Y'all work it out. What if the judge ordered somebody to go to mediation and the parties all got noticed? And the ones who showed up worked it out. How different is that than Smith versus Szyller? If you have non-participants at that point and they're not litigating, how is that different than Donna's conservator, and how's that different than Dee, and how's that different than Dave? I didn't know, but what I thought was, if there is a settlement that happens outside of court that's court ordered in that appellate jurisdiction, which in that case was Santa Barbara, San Luis, and Ventura County, that maybe they would say, okay. So Kirchner comes along, Breslin, if you will. And it's an interesting case. And it's now, this one's down in Ventura County. And, you know, the lawyers and I are chatting about Smith versus Szyller and wondering what the permutations of that are and what's the breadth of that. And so Uncle Don, it's a smaller state. This is like a $3 to $4 million state. Uncle Don has relatives, and they're all in the Midwest. They're very nice people. I met them, you know, but they live in places where you can buy a house with a white picket fence for like $100,000, $125,000. And they were, you know, Don was out here on the West Coast, and they had connection to some degree, but, you know, they were apart. Don wasn't married, didn't have children. And so, but he did have a trust agreement, and it was in a binder like you would get from one of those trust mills. I'm not sure it was, but I saw it and it looked like it was one of those. And so the trust agreement gives $10,000 each to 4 of those relatives in the Midwest. You know, 10,000, that's a pretty significant gift to someone who saves. And the residue, whatever that was, the trust agreement says is going to pass pursuant to Schedule A attached. And, you know, it was $3 to $4 million left over there, ultimately, when he passed. But guess what? There was, you know, we've seen this, there was no Schedule A attached. And so Don's nephew, Mr. Breslin, is the trustee, and he's also a $10,000 beneficiary. He recognizes that there are conflicts in taking a position there because he has a duty of impartiality among all the beneficiaries, right? So if, you know, he's a beneficiary, obviously he can't try to advance his own interests. But he tells the court, you know, I don't see a Schedule A here. And while I'm a $10,000 beneficiary, I don't know, you know, I'm not sure who my duty lies to on the Exhibit A residue, but in that binder, there's like a little pocket part area in the front, there were some worksheets, and one of the worksheets was partly in pencil, partly in pen, and there were a bunch of interlineations and erasures. But ultimately, there were 24 charities. 23 of them were Roman Catholic centric. One of them was the Pacific Legal Foundation, which is a conservative think tank up in Sacramento. And there were numbers ultimately that weren't crossed out. The ones that weren't crossed out added up to 100. So Mr. Breslin, as the trustee, says, Judge, this may be the Exhibit A. I don't know. And I'm not going to take a position because I can't on what I think you should do on this. But here's the worksheet. Here's the trust. I can't find the Schedule A. And so, court, you work it out and tell me what to do, which you know, is fairly honorable, right? Because I would think most you know, people in that position would say, you know, no Schedule A, and therefore I'm in the queue for a large portion of this estate based on my degree of consanguinity. So trustee files a petition for instructions. Brilliant. Giving notice. to all of the heirs, intestate heirs, because if there's no residual beneficiary, it falls to the pour over, right? And to the 24 charities, right? And I think that's Sir Thomas More I think on the left. And that's my depiction of the charities over on the right with the orphans. And that's my family in the middle coming to California to visit me. And the trial judge, at the request of counsel, because they knew what they were doing, ordered the case to mediation. So that's, that is not the trial judge, but that's my fair comment. Hi, go away. Work it out. So this is the actual notice that was used in Breslin. I did some deletions here because I didn't want to give any confidential information, but the notice of mediation itself is what we call the Breslin notice. And it was very terse, and it cites Smith versus Szyller, right? If we're doing a Breslin notice today, we're going to cite Breslin, except on the issue of attorney fees, perhaps. But it cited Smith versus Szyller and said in the Breslin notice, which is in the Breslin case, non-participating person or parties to receive notice of the date, time, and place may be bound by the terms of any agreement reached at the mediation without any further action by the court or further hearing. Smith versus Szyller. Okay, so now we can contextualize where we are, why we're here, and why it said that. And then the notice said rights of trust beneficiaries or prospective beneficiaries may be lost by the failure to participate in mediation, which is kind of what happened in Smith versus Szyller, right? They didn't call it a mediation. It was sort of there it was a sort of an ad hoc, who's litigating, the others were sent home by the judge kind of agreement. Here, a specific notice went out to all the parties timely, and timely in the sense of a 17-200 timely. So only 5 of the charities showed up. And so these family members, there's all, salt of the earth, Midwestern folks, they came in nice. The charities had representatives who were there, the 5 who showed up. 19, including the Pacific Legal Foundation, didn't show up. And so it was kind of, do you want to do this the easy way or the hard way? They said, what's the easy way? And the easy way is the 5 charities know what their percentages are on this worksheet. So that would be 100%, presumably, of their entitlement. Right? Arguably. I mean, they could have said, well, now we want more than 5. In fact, one of them did, or whatever, more than their percentage. And the family can share the percentages of the 19 no-shows. And they all said, yeah. And so I learned something about Catholic charities there, that they're not always charitable to one another, because there's different. Some were specific dioceses, some were churches, some were orphanages, some were legal entities like the Thomas More Law Society. They showed up, right? And they reached an agreement, and they said, here's how we're going to divide it up. And so David Breslin, he goes to the court and he goes, up, here's our judge, here's our settlement, and a bunch of people didn't show up. And of course, that unlike Smith versus Szyller, they did it the right way. They did a 17-200 notice. Everybody got served again. And all of a sudden, a number of those charities that didn't show up said, wait a second. That's not fair. We should get some of this. Even though they didn't honor the notice to appear at the mediation. And the trial judge, looking at Smith versus Szyller and listening to their argument, says, you could have shown up, and I ordered mediation, and they sent notice, and the notice said that you could lose your rights, and you still didn't show up, and now you're coming here to say that either needs to be done again, or we have to abolish the settlement agreement. He wouldn't do it. And so at that point, it was going up on appeal, but it was to the Smith versus Szyller court. So it was really interesting to watch how that, the evolution of that. And so the Court of Appeal, and there was two opinions. The first one said, absolutely, that's Smith versus Szyller. Court ordered mediation, you got notice, you didn't show up. And then there was a petition for rehearing with a very prominent appellate firm, and one of the justices, now retired, said, that just doesn't feel right to me. And the other two, including Justice Arthur Gilbert, is very prominent, wrote the lead opinion, said, no, this is essentially like civil default. You don't show up and you're told to be there and you got notice. The interesting part of this holding, right, in Smith versus Szyller, and to my probate litigators, this I think is a real important linchpin. The appellate court, to bail out the trial court, cites 17-206. The probate court has the power to establish the procedure. 17-206 is just an omnibus that says in a trust case, the trial judge can order the procedures the way she or he wants to, enable their equitable powers or the powers of the court. And so it's not specific statute. It's no different really than CCP 128, which says the courts have the power to do what they need to do to accomplish their results, and CCP 187 to some degree. But 17-206 now, there's a trilogy of cases that appellate courts have used to allow probate courts to do a lot of things that aren't statutorily specified. So as you practice your litigation in the world of trust, particularly, think of 17-206 if you want to be creative. The first real big 17-206 case was out of Los Angeles, and it was Schwartz versus LeBeau. Schwartz versus LeBeau was a removal surcharge case, right? And when I was practicing law, which is before most people were born, and we had to adhere to the statute, at least we thought in those days, the removal statute is very specific. You can remove under certain criteria. One of them, the one that was used most frequently, was hostility, but the law required the hostility to impair the trust, and the trustee would come in and go, I'm not impaired. I can't stand the beneficiaries, but I'm not impaired. And so, oh, okay, great question. And I'll get into Glen in a second. So the appellate court said, a judge in a trust case, when you're dealing with your trustee, if you want to remove them, you just trying to order your procedures and make your case go better. And so if something smells funny from a trustee, suspend them and or remove them. And it just created this separate inherent power outside of the statute based on 17-206. And that was interesting. And then I had a case in my courtroom, which was, I think, 2011-ish, called Christie versus Kimball, where I had a litigant she was down in Rancho Santa Fe, who had some of mom's money. She wasn't the formal trustee, but she had spent a bunch of it, which she said was for legitimate purposes. And I ordered her to account, and she said, you can't order me to account. And I said, I think I can order you to account. And so in Christie versus Kimball, that's the case where actually Justice Gilbert says, in trust world, accounting is the most elegant way to figure out, the hows, ifs, hows, and whys of an estate. And so the Court of Appeal said the trial judge can order an accounting whenever the trial judge wants under 17-206. So now with Breslin, 17-206 is the third in the big trilogy of appellate courts empowering trust judges to just do what they want in terms of procedure, and procedure can be substantive, such as trustee removal and surcharge, or suspension, and ordering accountings, obviously, and in this case, ordering mediation. So 17-206 is a thing, and we need to be cognizant of it, even though it's fairly innocuous in its verbiage. Court of Appeal says the probate court made participation in mediation a prerequisite to an evidentiary hearing. By failing to participate in the mediation, the 19 no-shows waived their right to an evidentiary hearing. It follows that the 19 no-shows were not entitled to a determination of factual issues such as Don's intent. Okay. And that's the holding, right? And in dealing with the dissent saying, well, you know, equity abhors a forfeiture, appellate court, the majority says, well, the 19 no-shows apparently believe that after the trustee and the participating parties have gone through mediation and reached a settlement, they should have been notified before it was signed, but that would defeat the purpose of the court-ordered mediation. So nothing is more important, expensive than a missed opportunity, right? So, and I'm going to weave in that Glen question now. Okay. In the civil world, there's an appellate case, I think it's 1987, but I'm not certain about the year, but it's right around then, when a civil court ordered a party to mediation. And the civil litigant, you know, I try not to, maybe we have civil litigators here. It's a different breed, right? They're just, everything to them is nuisance value. But having said that, editorializing, that in Glen, lawyer goes, you can't make me go to mediation. The Court of Appeal in that case never went to the Supreme Court, said, yeah, you know, our courts are free. And so if you're forcing somebody to go to mediation, they got to pay for mediation, then that kind of belies or, you know, contradicts our system of justice. Now, we all know that there's court fees that, you know, if you work in family law, there's 730 experts. Well, it doesn't have to be family law. There could be a 730 expert in any particular. You know, if there are receivers ordered, I mean, there are all kinds of costs associated with litigation that a court can impose. In Breslin, the court said, as part of its order, the trust is going to advance the mediation cost. And if it doesn't work out, we can just use this as a post-trial cost item. And so, at least on its face, in that case, there were competing parties, people who argued they were beneficiaries, people who argued that they weren't beneficiaries. It was not really fixed in terms of finite interest in the testamentary document, and so it wasn't really anybody's money; it was the trust's money at that point, and so it wasn't an issue. It was raised in every single brief, and the Court of Appeal goes, whatever, and they don't deal with Glen, but here's what happened, right? So I was just settling a case, right? You know, when the briefs came to the Supreme Court, the requests for depublication were substantial. There were a lot of them. The Attorney General came in. My friend, Julie Woods, wrote this 12-page scathing email that said, this is going to ruin California charities in perpetuity because now they got to lawyer up, and how can they afford that? Many local bar associations said, that's not how we live our lives. We do mediation because we want to and not because we're told to. And so I had every expectation the case was going to be depublished. But I did my job because I settled that case, right? But lo and behold, Supreme Court goes, no, this is a perfectly good decision. And we're not going to depublish it, and we're not going to take it. Glen, by the way, there was no petition for review back in the 80s, right? So all of a sudden, you know, our brains implode, and we go, well, why did they not want to touch that case? And I think, you know, we can only posit it because our Supreme Court is a policymaking body, right? You know, they're not so much interested in Mrs. Paul's graph as they are in how jurisprudence is dispensed in California. And so it kind of is a huge issue as to whether our courts are so inundated and the resources of the specific courts are so impacted, that we ought to have policies that can require ADR, because it's the only resource at our disposal that keeps people, out of trial. And so if that's their mindset, then okay, then I can see where they would say, absolutely, if a court thinks a case ought to be mediated, and the entity in our trust world at least is going to advance the cost, and it can be a cost item. Okay. Because as we know, in our world, at least in trust, right, in my experience, way more than 80% of cases that go to mediation resolve. So why would you force those cases to go to court because some party goes, I refuse to mediate. So I think I suspect that Glen is not considered a contemporary analysis anymore, right? This theory about courts should be free, well, they're not. And there can be expenses associated with litigation. So the question, how do you reconcile this decision with Glen and the general notion that efficacy is predicated on voluntary participation? Those of us who mediate, I do every day, different trust every day, right? I think the efficacy of mediation is often predicated on mandatory participation, because at the end of every day, people say, well, I didn't think that was going to settle, and it did, lo and behold. So it's kind of a shift in terms of how we look at things. But I think this is really a shot across the bow from the Supreme Court. So I know I don't want to push too much into this. I have 5 minutes or so, and then I want to be able to respond to questions. In Breslin, right, the charities, when we played Catholic schools in high school, right, there was always bloodletting, right? So they threw each other under the bus there, but you don't have to, right? So in mediations that I've had in the last couple of years since, it's been 3 years probably since I resolved Breslin, hundreds of mediations, right? No, you don't have to throw them under the bus, but you can avoid a common fund request by, as part of a settlement, weaving in the attorney fees of the participants into the resolution for the non-participants to equalize that. That's one thing you can do. Another is, I had a case with dog charities, right? And I said, hey, there's a bunch of dog charities that aren't here. Do you want to just take their shares? And they go, no, these are, these are dog charities. Judge, we're not going to throw them under the bus. But when the case was, $50,000 or $100,000 apart in terms of resolution of the estate, yeah, the non-participants bore that differential because they weren't there and they weren't participating, and it made sense. And so that's, there's so many different ways you can deal with non-participants. It's not an all or nothing. It's not a forfeiture necessarily doctrine, right? Breslin is a bit extreme because the charities there had no urgency to want to enlist the inclusion of some of their other arguably related institutions. So our courts, at least our trust courts in those counties, Contra Costa, where there's a specifically dedicated trust and estates court. What about probates and conservatorships, right? 17206 is only relating to trust. I had a question this morning from a lawyer in Northern California in email about a probate case, right? And I actually got an inquiry from a judge in San Diego, judge from another county, who just said, what should I do about Breslin and other probate related areas that aren't trust? And if you look at CCP 128, it's not that different from 17206. And if you look at, in conjunction with CCP 187 and 128, they kind of say the same thing that 17206 says in terms of the inherent and generic powers of courts to achieve the results that are compelled by law. And so maybe the Supreme Court was thinking that 17206 is just the first step in moving the civil world, not that we do any of that necessarily, but certainly probate and conservatorship cases into a compulsory mediation order. And I will tell you, Los Angeles, for example, has within a week of Breslin coming out, they had already had logged into their macro system a Breslin order as to all of their cases, regardless of whether it was a trust specific or not, in the probate courts. And so also remember that not every settlement requires you to pay, a high price mediator, right? There's mandatory settlement conferences. Why would you not want notice to go out and have in a mandatory settlement conference before a judge, an assigned judge, to be able to resolve a case where there are non-participants? Of course you would want to do that, right? So, which is kind of traverses any Glen argument because there's no cost associated with that. As lawyers, right? People come in and go, my family members are litigating, but I'm the middle child, or I'm the peacemaker, or I'm not resourced to get involved with that, or let's just see what happens. Within the paradigm of being non-negligent as a practitioner, I think the difference is that Breslin says you can't tell your client, just let it happen. You have to do something. But the real question is, what do you do, right? Because if you do a joinder as to one side, the relative, you're picking sides within a family, so that's touchy in our world. And then what if the other side wins? Is your client going to get popped for costs? If it goes to trial, and if you do a request for special notice, that's not going to be enough. That's just a notice. So in the Breslin Smith world, how do you render objections to anything that adversely affects you? Do you file a notice that says, I only object to something that adversely affects my interests? I don't know. I mean, this is a bit of a new world, right? But I don't envy the practitioners whose litigant they don't want to hire you, I guess, but I think you have to tell them that they need representation, because the Smith/Breslin world allows things to occur substantively, which can adversely affect them, as we saw in Smith, to the tune of hundreds of thousands of dollars without their participation, knowledge, or consent. And so it's kind of huge, right? And what if they came back and go, well, the lawyer didn't tell me that. And so is that, is that within the standard of care? So I know I held to my hour. And so let me see if there are questions. I'm sure there's all kinds of great questions here. So I mentioned Julie Woods. She was in here. Julie, she was the former research attorney for Judge Sugiyama, and then she was very heavily involved in probate curriculum, and then she went to the Attorney General's office when she wrote that letter, which I'm sure she now regrets. But I think she was here at some point in time. Any other questions by anyone? Happy to address them online, offline, but there's no such thing as a bad question. And specific, non-specific. Anne, do you have any questions?
I don't.
Well, you ought to. This is the whole. I don't know the answers to a lot of these questions, right? I don't know where we're going to go with this, other than it makes mediation really interesting, and it makes strategies for the litigators very important, because you know.
Joel, you have a question? You want to put it in the chat for us?
Oh,
Or go ahead and ask it. Go ahead.
oh, okay. Well, I just wanted to say I was sort of relieved because I hadn't known the names of these cases in advance of the program. And I was very concerned that someone was saying that that one could be ordered to mediation and that they would be bound by this, by the process. And apparently that's not quite so. Mediation, I've always understood, was voluntary, but if the court tells you you have to go, you have to show up. And in these cases, they didn't even show up.
Correct.
So if they had showed up and said, I don't agree, they would have been okay.
Okay, it would have been perfect, right? If you said, I'm not going to agree to that settlement, well, you can't force a settlement on parties, right? If you want to litigate, you're entitled to litigate. You're entitled to your day in court. But this is, it's kind of a little akin, Joel, to a civil default, right? Where somebody doesn't respond to a summons and the court just signs a judgment, which, hopefully
Yes.
has a declaration supporting it, but sometimes it doesn't. And I think because, our world is fairly confined in trust and probates, right? We kind of all know each other and we live in the same context, and our judges, we commune constantly. But when you get to the appellate level, those aren't probate judges. There's mostly former civil judges or criminal court judges, and this is kind of new to them. And so if they want to analogize it to civil default, it doesn't surprise me, because our appellate courts do all kinds of things that I think are odd. The question is, how do indigent beneficiaries or those with minimal interests meaningfully protect their interests at private mediation? You get on Zoom, your client should notify who's ever sent it the notice saying, I will be available either on FaceTime or on Zoom or Teams or Blue Jeans or whatever, whatever medium they're using. And I'm going to physically be there available to participate without a lawyer. I mean, I did it yesterday. I've had two non-represented parties yesterday. One was in a hospital and one had COVID up in Portland, and they weren't lawyered up, but they knew they had to be there. And it makes it just makes mediations really interesting to have represented parties, non-represented parties, Breslin parties, heirs who have no clue as to even why they're getting notice. It's pretty interesting. It's for a neutral, it's really fun. Well, at least a trust neutral. You throw a civil neutral in there and they have, why all these people here? But so yes, if I think a court were to say everybody's going to split the cost equally, that might be a problem. But when we're dealing with estates, the number of illiquid estates that we deal with are minimal. And so, if the resources are there, and it's a moderate size estate, which everybody who owns a house in California arguably has a moderate estate. Yeah, you can have the estate order paid in up front and let the chips fall where they may, because such a great proportion of these cases resolve that you never wind up allocating costs of mediation. I did it once in way more than a decade of doing trust, probate, and conservatorship cases. I allocated mediation costs once.
Anyone else?
These are all good questions.
Yep. Doug, I know you have a question. You must have a question. Maybe not. Oh, something in the Q&A. There we go.
Let's find it here.
How could a court order an illiquid trust to go? How could a court order an illiquid trust to go? Sorry. Wrong
Yeah,
emphasis
that,
on wrong syllable.
I think that would probably not happen. Right? Because who's gonna, if it's a if there's no expense associated with it, sure, because there's a number of courts that have settlement protocols that lawyers will volunteer for maybe the first 2 hours of their time. And so in many counties, there are those opportunities. But no, if there's no, the mediation will never take place if there's no resources and right. I never ordered in a liquid. Well, how often do you see a liquid trust, right? That's grounds to terminate the trust, even if it's irrevocable, if it's not economic. These are all good questions. Anybody else? So, okay, so such a pleasure being here. Even though I'm a professional neutral, I am a pensioner, and if you have any questions, give me a holler. Happy to talk to you offline. Always available remotely, and I do a number of live matters. I like, if I'm in Northern California, I like to be on Friday. I don't typically charge to travel or anything like that, but it's easier for me to travel if it's live on Friday. But otherwise, Zoom any day of the week and we're good to go. Or if you just have a question you just want to ask me, just ask me a question. We'll chat about it either through email or on the phone. And happy to chat with anybody, because it's what we do, it's what I do, and we ought to keep our community together.
Thank you so much. And you do, he's accessible through JAM's website. If you go, you can find him on the JAM's website.
Oh yeah, there's a pretty picture and all that stuff.
Yeah.
Yeah.
I also wanted to just thank you very much. But before everybody goes, I wanted to quick remind everyone, if you are intending to register for the MCLE Spectacular this year, which is on November 18th, please do that over the weekend. We need to get our numbers. We need to make sure that we're going to be able to actually get this done in person this year. And so if you are intending and you just to put it off, please don't put it off. Please make it a priority to get that done this weekend. We have some amazing speakers and some great programs, and we've scaled things back a little bit. So not going to have quite as, our goal is to not have as many people, but we'll have a good number of people. We need a good number of people. But we've scaled things back a little bit, so there'll be a few less people, and we have less programs, and we just want to make sure it's not as crowded as it usually is. So, but please, if you're contemplating coming, please do register over the weekend or today, and we'd appreciate that. But thank you, Judge Reiser, for doing this for us today. Thank you, JAMS, for helping us out. Thank you, the State Planning Section, for getting this together for us. And everybody have a great weekend. Okay.
Thank you, Ann.
Thank you.
It's a pleasure.
Bye-bye, everybody.